There we go. So again, welcome everybody. I'm going to start by introducing our two speakers and go directly into the presentation. And then following the presentation, we'll have question and answer. We'll run till 10:30 at the very latest, or until we run out of questions. Our two speakers this morning are Sally Dworick-Fisher, who is the lead attorney of the Workplace Justice Project, and Tyra Robinson, who is an attorney with the Public Justice Center. Tyra has been with us a little over 2 years now. The Workplace Justice Project, in collaboration in co-counseling with Gallagher and Avelius and Jones, brought the lawsuit that we're going to discuss this morning to extend unemployment benefits. It was a lawsuit against the Hogan administration that was ultimately successful. I'll let the team talk about both how the lawsuit was brought and also the impact of the lawsuit, which was very important to us. So with that, let me turn it over to Sally and Tyra.
Good morning, everyone. Thank you so much for coming this morning. It's really a pleasure and an honor to be able to talk about this amazing, probably once a decade event that actually made such a huge difference in the lives of so many people. And I think what Tyra and I are going to talk about today is a couple things. You'll hear about the chronology of the case, sort of how it came to be, our relationship with our clients, and a very, very heavy theme of an inspiring time where our clients' voices were definitely heard by the courts and in the court, and really moved the court and made a difference. So I think this is really sort of an example of what PJC does best, which is, sort of elevating the voices of our client communities in a way that makes an impact for the broader community and promotes justice. So I am just going to sort of dive right in a little bit in terms of the background and sort of how the case came to be. So as some of you may or may not know, we were hearing from folks that were going to be cut off from these pandemic benefits. And we started looking into it, and it turns out that in Maryland, something like 85% of all unemployment insurance recipients were on these federal benefits. So when the governor announced that he was going to terminate the program prematurely, that meant that 85% of folks, something like 200 to 300,000 people who were relying on these federal benefits, were suddenly going to be cut off 60 days early. And it was going to come, during the summer months where kids weren't even back in school yet, and the timing was particularly bad. So we started investigating. Well, is there a legal remedy for this? Could we do something to stop it? And in the midst of all that, there was another lawsuit that was brought by Alex Summerfield, and we saw that somebody else had brought a similar suit and decided to dig in and go full bore and see what we could do with a corresponding suit. And because we knew that this was going to be a super intense, we had, I don't know, something like 30 days, or no, I'm sorry, 30 days. We had like 2 weeks to reverse this decision. So we were all in. Luckily, we had friends at the firm of Gallagher, Avelius and Jones, who, when we approached them, they said, this is right up our alley. We're in it with you. And everybody just rolled up their sleeves and started drafting. And one of the key things, of course, was finding plaintiffs and clients whose experiences were both difficult and would resonate, really sort of painting the picture of why the early termination of these benefits was not a bad policy decision, right? Because we had to make the case that it was unlawful, but what the impact was going to have. Now, I'm going to turn it over to Tyra in a minute to talk about the plaintiff selection and our relationship with the clients. But I want to point out that legally, to get this reversal of the governor's decision, we had to prove that it wasn't about the policy. We had to prove that we were likely to succeed on two particular claims. And the legal claims that we had there was that the governor's decision really violates Title 8 of the Labor and Employment Code, which is the Unemployment Insurance Code. And what we were saying there is the Unemployment Insurance Code requires the governor, or requires the Secretary of Labor really, to maximize benefits that are available from the federal government. And in a pandemic, when the federal government is offering free money to keep people on special unemployment insurance benefits, where the unemployment insurance rate is upwards of 6% and up, you do not have the discretion to just say, no, sorry. The law requires you to maximize those benefits. So we had to prove that we were likely to succeed in winning that legal claim that the governor was in violation of the Unemployment Insurance Code. And I should say, really, it was the Secretary of Labor in violation, but the governor was sued in his official capacity. So we had to prove that. And we also had another claim, which was an equal protection claim. And our equal protection claim was that it's not rational to suddenly cut off 85% of people who are on unemployment insurance, to just cut them off and leave another 15% on, because there's no likelihood that 85% who you're going to cut off is somehow more likely to get a job in the future than the 15% that you're not cutting off. So we had two claims there. One was that it violated the Labor and Employment Code, the UI code, and the responsibility to maximize federal benefits, and the other was equal protection. So we had to prove that there was a likelihood of success. We also had to show, which was critically important for this case, that the balance of the harms was in favor of keeping the benefits flowing rather than cutting people off the benefits. And I think that balance of the harms, you'll see, became a theme both for the judge and for us and for our presentation of the case. And critical to that really was the plaintiffs and the plaintiff's experience. So I'm going to turn it over to Tyra now to speak a little bit about how we went about that and our relationship with the clients.
So we got in touch with potential plaintiffs in a couple of different ways. And the first, and it kind of went in phases. The first phase of potential clients came through when Sally wrote a great op-ed, and it kind of went in tandem with, before we even knew it, our litigation strategy, in that it generated some interest and was able to get people to call into the PJC. And so that's kind of how we started talking with people. They emailed in response to the op-ed, and we followed up with them if we determined that, we were able to. And so that was one of the first things that we did. As it goes with public interest law, we wanted to help everybody. And unfortunately, we couldn't, because of those narrow circumstances that Sally mentioned, had to put the puzzle pieces in order to meet this standard to succeed in the case. And so we kind of had to weed people out in a way. And people started flooding in once we brought in another instrumental partner that we had, which was Unite Here Local 7. And they were instrumental in various ways, one which I'll touch on now and another later. One was identifying their folks who were affected, their members, and sending them to us to speak with. And second, with their relations with the media. And so they came into play in two really crucial pieces of how we went about, highlighting this case in the media, and also making sure we were continuing to keep the affected people in mind as we were litigating. Kind of a little bit about how those conversations went. Of course, maintaining confidentiality. It was hard to get people to share the worst case scenarios of what was going to happen to them, understandably, potentially going to happen to them. It was hard to kind of frame that in well, tell me the worst thing that could happen to you. And that was important for the temporary restraining order, and then also for the preliminary injunction standards, for us to be able to show to a judge, this is how people will or could be affected. And so, you know, I think that at least for me, as I was talking with folks, it took a little bit of phrasing differently, remembering to keep care and compassion in mind as people were sharing things that they had gone through and things that they could potentially go through. So there was some trust building that went into building the narrative of these folks' stories that we could share with the judge. And I think, as Sally will share a quote with you later, that really came into the judge's decision as he was deciding this case. After we narrowed down everyone's facts, how we did it is we met as a team to figure out who could best meet those standards that we could put forward in the case. And for folks that we couldn't really help in the moment, we just shared with them that if we win, and it would be, you know, an uphill battle to do so, they would be positively affected. And so that kind of lightened the blow, in my opinion, to telling somebody, no, we can't help you at this time. And I think that's all I'm going to share on the plaintiff selection on that piece.
Great. And, you know, if anybody has any questions along the way, we're happy to answer in the chat or otherwise. So as Tyra mentioned, it was fairly intensive, you know, getting to know the plaintiffs and getting them to share their experiences. And we're just going to share now a little bit of the chronology to sort of lay out what a, you know, what a sort of crazy timeline this was. So, you know, we just, you know, we roll up our sleeves and on Wednesday, June 30th, we file our lawsuit. As I mentioned, we had two basic claims there, one for violations of the Unemployment Insurance Code and the other for the Equal Protection Clause. The very next day, defendants removed the case to federal court, meaning we had filed in Baltimore City Circuit Court. To remove a case to federal court, a federal court needs some sort of federal jurisdiction. Usually, often that's a violation of a federal statute or the US Constitution, or there's a federal law. So defendants removed our case, and although we had not pled any federal claims, they had an argument that we had pled federal claims, and they removed the corresponding case that I had mentioned earlier. It was called Harp versus Hogan. They removed that Harp case. Harp did actually plead some federal cases, but nonetheless, they removed us both. That same day, I think it was that Thursday, the 1st, we were able to get on file an emergency motion to remand, have a hearing before a federal judge late that afternoon. I think it was 3 or 4 in the afternoon. We had a fairly lengthy hearing with the judge. That night, the judge issued an order saying, you know, there is no question of federal law here, and I am remanding them to circuit court, or, you know, sending it back to circuit court. There's no basis for me to get involved here. I'm going to send it back. At that point, that was Thursday. That Thursday, the defendants came back with their opposition to all our papers. They opposed the temporary restraining order motion. We filed a reply that day, and the judge set a hearing for the following day, Friday. So that Friday afternoon, we had a virtual hearing with the Baltimore City Circuit Court, which was, I've never seen anything like it. I think that, you know, it's partly due to the pandemic, partly due to the fact that the judge was sort of, he was without serious tech support that day for whatever reason, and he was, you know, trying to get us going on that, you know, on that Friday as soon as possible. So he just did the Zoom himself. I want to say there were, Tyra, correct me if I'm wrong, but were there 500 people logged on to the Zoom hearing that afternoon? Yeah, so the poor judge is trying to manage 500 people on Zoom and telling people, you know, silence yourself and whatnot. And people are chatting during the hearing. It was really, it was both extraordinarily unusual in terms of a court proceeding, but it was also, for me personally, I thought it was somewhat of an inspiring demonstration of really the public being involved in a public hearing. so anyway, the Zoom function of that hearing is somewhat of a side note, although it was, it made the hearing go on longer. Yes, that's true. As Deb pointed out in the chat, 500 is the maximum capacity. So in any event, that was a Friday afternoon. And we were really up against the gun there because there were some timing issues that were going on in the background. And one of them was that we needed really the governor to reverse his decision basically by midnight that Saturday. He had, the way it worked was there was an agreement with the federal government, and Governor Hogan had given 30 days notice that he was terminating that agreement. And the 30th day was that Saturday at midnight. So he had, if barring anything else, Saturday at midnight, the benefits were going to be cut off. So Friday afternoon, I think we left the courthouse around 6 o'clock, and the judge had indicated that he wanted to think on it overnight, or wanted to work on it overnight. So Saturday morning at July 3rd at 10 a.m., the judge sends us his decision, and he granted the relief we sought. He didn't go for the equal protection claims, but he did show that we were likely to succeed in proving that the unemployment insurance law requires the Secretary of Labor to maximize the use of available federal benefits. And in that order, which came down at 10 a.m., he ordered Defendant Hogan to immediately, and in no event later than 11:59 p.m. that night, to rescind the notice that he had given saying we're cutting off the benefits. And because it was a temporary restraining order, under the rules, temporary restraining orders can only last 10 days. So he said, Governor Hogan, you have to get with the U.S. Department of Labor by midnight tonight, and otherwise this order expires July 13th, and we'll have another hearing later on to determine whether to continue this injunction. So we were like, ecstatic at the victory, but of course that was not the end of the road. Defendants then moved to stay the TRO. In other words, they said, we think this TRO shouldn't go into effect and we shouldn't be bound by it. Can you stay the TRO while we go forward with appeals all the way up the chain? The court said, no, we're not going to stay the TRO. You have to do as commanded. Then they moved to stay by appealing to the Court of Special Appeals. That was late in the, I want to say 4 in the afternoon that Saturday. We filed our opposition to that. The Court of Special Appeals denied that Saturday night. I don't know what time it was, if anybody remembers, 8 or 9 at night that Saturday. And then they file a petition for cert in the Court of Appeals. And we opposed that, I want to say 11 o'clock that night. The following day, so, we're all on pins and needles because, the governor was still ordered to rescind his notice, but we weren't quite clear whether he had done that or not. That Sunday, we get confirmation that he had done that, and then the Court of Appeals also dismissed the governor's petition for certiorari. That was somewhat on a technical, or not really a technical ground, but the court found it didn't have jurisdiction for somewhat, anyway. It found it didn't have jurisdiction, so the defendants then filed a motion for reconsideration. I'm sorry, I'm just reading Deb's correcting me in the chat. So, and yes, that's true. The governor did have to comply, but we had not received confirmation that he had complied until the following day. So, Sunday, the defendants filed for reconsideration in the Court of Appeals. The following day, that Monday, the court rescinded its prior dismissal. So all that meant is that the court's order stayed, and now we had to prepare for a hearing on the next phase. So there's a temporary restraining order that lasts 10 days, and then we filed for a preliminary injunction, which would last an even longer period of time. And that was sort of, that preliminary injunction hearing was treated more as a mini trial. So that was that Monday, I guess. Monday, the Court of Appeals rescinded its prior dismissal and denied the cert petition. And then the following Monday we spent the week preparing for the preliminary injunction hearing. And that Monday, defendants put on 4 witnesses, and with cross-examination and closing arguments, I think it turned into about a 7-hour hearing or something like that, during which briefs were being filed. We filed the brief that weekend. They responded at one point. Monday, I want to say at like 1:30, we got another brief while we were in the hearing. But thankfully for our part, the following day, the court again ruled in our favor and issued an injunction finding again that the Unemployment Insurance Code does not give the governor or the Secretary of Labor really discretion over this particular issue, and that this wasn't a policy issue, it was a legal issue. And as I mentioned, one of our themes is going to be the judge really hearing the voices of the clients and of our client community. And I just wanted to share, some of you may have heard this before, but I want to share one particularly compelling excerpt from the judge's opinion, which Tyra's about to share with you as well. All right, so you see it there. And this is, in my experience, an unusual display of empathy, compassion, humility. So the judge says, in its global scope and in the anxiety that almost all people experience over threat of disease, the impact of the pandemic has been universal. But the brief stories of these plaintiffs reminds the court that the impact of the pandemic has been cruelly uneven. Some have suffered death or debilitating illnesses themselves, in their families, or among their friends. Others have experienced severe economic hardship from involuntary unemployment or the inability to work because of the need to take on childcare or elder care responsibilities. As one who has enjoyed the privilege of continuous secure employment, the court is particularly struck by the plight of those who have had to struggle with irregular or no employment. Mic drop, I guess. That was just an unbelievable, and it shouldn't really be, I guess, is the point. But it was a very moving and inspiring piece of, what is usually otherwise dry legal writing, and we tout that passage as like, it was wonderful to see that. And I think, our clients were so sort of relieved and overjoyed that they were heard. So that's sort of the reliving of what happened, when, and why. And, sort of on top of this and all going on at the same time is also a somewhat parallel press track or communications track that Tyra was really involved in, where we were sort of working to keep people informed of what was going on and to keep the public engaged and all eyes on what was happening here. So I'm going to turn it over to Tyra to talk a little bit more about that.
So I've done some screen grabs of our Facebook activity during pretty much the duration of this case. And as I mentioned earlier, it was really important to have Unite Here as a partner because they use their Facebook really artfully as well to make sure that their members were informed of what was going on because they did have, representative folks from their membership that were in this case. And then also using their platform to amplify the work that we were doing. And so in addition to what they were doing on their Facebook page, we were also really active on our Facebook page. And I'm just going to share a few metrics from our page. So this first one is the first major update post that we had after we filed. And as you can see, we had almost 6% or 6 times higher distribution than our normal Facebook activity. We also had 423 people reached. And so that kind of shows, that people were watching to see what was going on. As we shared, there were a lot of Zoom participants during the actual hearing, and a lot of people wanted to know what the follow-up was as well. This screen grab is from June 29th to June 30th, and that was the timeline that we filed. So the day before filing and the day of filing of our complaint. And I just wanted to highlight that we had over 100% reach on our Facebook page over that time period. These are 2 of the major posts that we made about what was going on in the case. The first was the first post that I showed you that had the over 6 times distribution rate. And the second one was another article that we had shared, also illustrating the work that we had done in filing this complaint. And just wanted to mention that we had 46 likes and reactions. And so engagement with the content that we were sharing on that first one, and then 12 on the second. And then lastly, this was the time period that we did a press conference in conjunction with Unite Here. They hosted it on their Facebook platform, but we also received some engagement on our Facebook page. And this was a press conference date. Our reach went up, even though it was on Unite Here's Facebook. And I just wanted to highlight that it was over a 400%, or excuse me, almost over a 300% Facebook reach. And so what this illustrates to me is that our social media followers are actively engaged with our content and actively paying attention. And if we pair a proactive social media approach with a media strategy, then possibly for future litigation, then we may be able to advance our mission through more organic people activation. And so that was really, really striking to me as we coordinated with Unite Here. I also did an update Facebook Live with them to, I think, some point in the middle of between these 2 hearings of what was going on to their members. And they were really engaged with that. There was a lot of comments on their page with that and their live event. And so people were really interested, I think, to hear what was happening and to know what was going on, what the updates were, and specifically what that meant for them, because they were noting that they were still seeing issues with their unemployment insurance benefits, not being active, not being able to file weekly certifications. And so explaining to them kind of what that meant and what the timeline would be for them to actually see a change. And I'm going to turn it back over to Sally.
Yeah, so we're just going to wrap up by talking a little bit about the impact here. Now, as we described, these were federal pandemic unemployment insurance benefits. So these were fully funded, federal dollars that were designed to go to primarily folks that wouldn't otherwise be covered by unemployment insurance benefits, like independent contractors, or even people that didn't have enough work history, like you had just, for regular unemployment insurance, you have to have had a certain amount of work history in order to be eligible for the benefits. So PUA, or pandemic unemployment assistance, is designed for independent contractors, self-employed, what people call gig workers, and that really was a lifeline for a lot of people. There was also a program to extend benefits beyond, normally benefits last 26 weeks and you're expected to get another job in that time. But during the pandemic, there were programs to extend that time period. So these federal benefits were money flowing to the state from the federal government. They weren't part of Maryland's unemployment insurance system. What it meant to force defendants to continue those benefits, according to our comptroller, it brought an estimated $1.5 billion into the state over that period to continue to pay those benefits for people that still couldn't find work. And that $1.5 billion has ripple effects, because those are benefits going to people that, they're not socking it away in some IRA or something. They need to spend it. So when that gets spent in the economy, the ripple effects multiply the impact. And according to the Maryland Center on Economic Policy, another partner, the estimated impact was over $2.4 billion to the state of Maryland in these benefits, and the impact on the economy was apparently tremendous. Apart from that, we just got a number of calls and emails just thanking us that people didn't have to worry about what they were going to do all summer. They had a little bit more of a cushion to continue to look for work, knowing that when school started again and in September, the federal benefits were going to expire anyway. So, this is a sort of, as unemployment insurance always is a temporary safety net, but we were able to give them, a few more months of that safety net while they had a little cushion to get back on their feet. So I just wanted to, I know she's going to kill me. I just wanted to recognize also Deb Gardner is here with us, and she was also actively involved throughout this litigation, and it was really a tremendous team effort between Unite Here, Gallagher, PJC, all hands on deck for, looking at that chronology, I'm realizing, it was only really about 3 weeks, but it felt like longer than that. So I think we can open it up to questions now, where we can have a conversation. Happy to answer folks' questions, and we can go from there. Elizabeth, how many people have had to move out and are now in a situation less conducive to a job search? Do you mean because the benefits ended in September, or?
Yes.
So I don't have the numbers on that. I don't know if I don't know what the numbers are nationally. I know that there are an estimated like 7 million people that cut off pandemic benefits when they expired. I will say that once we won this lawsuit, we did pivot to try to assist with federal advocacy to continue the pandemic benefits. We also tried to reach out to encourage the governor to use ARPA funds to continue, to make continue benefits for Maryland folks, even without the federal pandemic program. But we were, not surprisingly, unsuccessful there. Quiet crew. Well, I guess the only other thing I would say to tie it up is that, you know, this could not like, as mighty as the PJC is, we couldn't have done it just with the few attorneys that we have on this issue. And really want to give a shout out to Gallagher, Avelius, and Jones for their pro bono work on this. Some of you might have seen that, you know, the governor's attorneys had a bill for $400,000. And that's not even particularly high, but I'm sure that Gallagher, Avelius, and Jones donated at least as much to working on this case. The plaintiff's attorneys did not get attorney's fees for this case. So, you know, we're eternally grateful to them, and it's somewhat a shame that we have to find pro bono partners to work on big issues like this sometimes.
I add one quick thing as well. I don't know that, I apologize if Sally already mentioned this, but none of us really knew unemployment law, unemployment insurance law. I mean, I had represented people in individual unemployment insurance denials decades ago when I worked at Maryland Legal Aid, but we didn't know the statutory provisions that we relied on in this case. We didn't know unemployment insurance and how the system worked at that level to sort of, we didn't know hardly anything at all about the federal benefits and the federal state interplay and partnership that was so critical to winning this case. And the Workplace Justice Project folks at PJC just dove in and learned all of that stuff by the seat of their pants in a matter of days, maybe even hours. It was just extraordinary, extraordinary work, extraordinary accomplishment, extraordinary victory on the steepest possible learning curve, and everybody made it to the pinnacle. It was really amazing, and I can't congratulate them and the Gallagher folks often enough for such an extraordinary outcome.
Hear, hear. Anybody else have any other questions or comments? This has been educational, and it's good to hear. Real good to hear that PJC and Gallagher and everybody could get together that quickly and have such a major impact. I mean, PJC has done many cases over the years and have produced millions and millions of dollars for our clients, but I think this might be the single biggest case in terms of impact on our clients at 1.5 billion plus ripple effects. And that's pretty outstanding. So thank you, Sally and Tyra and Deb and the whole team. If we have nothing else, I will say it's justice for breakfast. We've had our breakfast. You can all go back to work now. Thank you so much for joining us all. Bye-bye.
Thank you.